Good afternoon, everyone. Welcome to the latest episode of Association Matters. Today's episode will be based on some of our wild and wacky neighborhood disputes and how to handle them. Joining me today is Lisa Littman, the Vice President of Property Management Operations for Lang Management Company, and attorneys Jeff Rembaum and Alan Schwartzseid of Kaye Bender and Rembaum. We will cover a few examples of owners' disputes and what options you have in dealing with them. Please keep in mind that this seminar is not for legal advice on a particular issue that your association may be experiencing. It is discussing legal issues in general, not specific to any association. Please also keep in mind that enforcement tools are different for homeowners associations and condo associations, so the answers to those will be different. So with this, Jeff, one of the recent issues we dealt with is an animal, a service animal at a clubhouse, a neighbor who's not happy about the animal being allowed at the clubhouse. The documents actually prohibit this breed of dog, but there is a renter who is a veteran who has the proper paperwork and controls the dog even when it is in the gym. So the concern is A, that the dog is listed in the documents that it shouldn't be there, and B, when this owner is working out in the gym, if the dog is not on the leash, they put the leash down while they're working out, but it's still controlled. It's an issue for these residents, and unfortunately, it's become a neighbor-to-neighbor dispute in that community. Do you have any advice on how to handling something like that and legally what they should be doing?
Hi, everybody. Nice, simple question to get the day rolling. Appreciate that, Marita. Wow, that was a lot there. So we have a dog, and the community doesn't allow dogs to begin with, or doesn't allow that breed in any
That breed of dog. Correct.
Sure. But this person has what we're going to refer to as an assistance animal of some nature, right? So when we're in the ADA, when we're outside the association's gates, everybody, we're dealing with the American with Disabilities Act. Now walk through the gate and we're dealing with the Fair Housing Act. Interestingly, the ADA only has one type of animal, and that's the service animal. It can be a dog and it can be a miniature horse. Why a miniature horse, you might ask? Actually, for rural areas, they're really, really easy to train. Well, they're easy to train no matter where they are, but in rural areas, they're great for helping those that are visually impaired, most especially if you are blind. So that's how miniature horses actually made the list. Florida, back in the 1800s, actually had quite a few miniature horses. It's a whole The Land Remembered was a great book if you want to read about old Florida. I think Netflix is making it into a 6-part miniseries. Should see it the next
Jeff,
year. So
if you remember as well, I think we have a pig in one of our associations still to this date.
there you go. So that brings me to, that wouldn't necessarily be a service animal as much as it would be an assistance animal, a emotional support animal.
Correct.
So under the assistant animal heading, under the FHA, we have two types of animals. We have the service animal, and then we have the emotional support animal. Here, we're talking about a retired military individual who has PTSD. He has a disability. The disability has been shown to affect a major life function, and the animal is prescribed, if you will, to help ameliorate that condition, that disability. So therefore, even if no dogs are allowed, no animals of any kind are allowed, that individual would be allowed to have the animal. Under the federal law, which governs this particular issue, the animal only has to be under the direct control of its handler. And there is a debate out there, well, if we require a leash law at the association, well, if it's the association's leash law, that could be problematic because it's in direct conflict with the federal law that says the animal could either be on the leash or under the handler's control. Now, you could probably probe that out a little bit. I would never suggest to an association to do this on your own, because you've got to know how to phrase and ask the question so you don't get yourself into hot water. why does the individual need the dog to not to be on the leash? There could be legitimate reason for that, which is why the animal needs to be under the control of the handler. Maybe the animal is trained to perform a particular task and it can't do that task if in fact it's not on, if it's on the leash. So maybe there needs to be an exception. But in any event, the OEO, which is the Palm Beach County anyway, and the Office of Equal Opportunity, has the enforcement functions for the Fair Housing Act. And they're the ones that make the initial determination of whether or not there is a violation. There is little doubt in my mind that if somebody who was lawfully entitled to an assistance animal were to say, this animal is under my control, the association is fining me because I'm not using a leash, I think they would find exception with that and have a problem with that. And it'd be an uphill battle. So in any event, um, I'm a huge dog lover, everybody. And by the way, I am Jeff Rembaum, my partner, Alan Schwartzseid. We are Kaye Bender Rembaum. We represent around 1,800 community associations around the state. We are in Palm Beach Gardens, Pompano. Alan is in Orlando. We have an office in Tampa, pretty much a statewide practice. If you're happy with your lawyer, stay there. If you're looking around or thinking of changing, we would appreciate the opportunity to tell you a little bit more about us. As you can see, it's we love playing, Alan and I especially love playing the game of Stump the Lawyer, which is where you get to ask whatever you want, which is where Marita's questions come from. And you'll see she's going to try very hard as this little webinar, and we have this hour together go on. She's got some very spicy, picklish scenarios that all come from the real world, sadly. But it's just becoming such a interesting world as it's changing over the last 30 years that I'm doing this practice, and it's getting a little bit more, what's the word I'm looking for, Alan? I guess in your face, right? But I think I've answered your question there with the dog. The dog is allowed to go, by the way, and to get back to your question, anywhere the individual, the homeowner, is allowed to go. So therefore, the animal would absolutely be allowed in the clubhouse. Here's something as a big dog lover, but I still have a problem with this particular part of the analysis. If the individual has an emotional support animal and they can leave to go shopping, they can leave to go to work, all those things, but then they have to bring the dog to the clubhouse. I don't get that. I will never understand that. But in fact, that is what the federal fair housing laws do provide for. So I could have the emotional support animal, which can be in my home Monday through Friday from 9 a.m. till 5 p.m., right? Maybe I have a dog walker, hopefully in the middle of the day, or come home and clean your apartment from the mess the dog made because you didn't take it out. But then you want to go to the clubhouse for 30 minutes and you can't leave the dog at home for the 30 minutes. Why not? I'll just never understand that rationale. It would be nice if we have some new rules that come out governing assistance animals. I think it's gone a little bit too wacky and a little bit too far when it comes to things such as allowing the dog in the clubhouse. For that example I gave, where the individual is still able to go to work and they leave the dog, why should they be allowed to bring the animal into the clubhouse just because they quote unquote can? That doesn't make any logical sense to me, but be that as it may.
I got one for Alan.
Okay. Well,
We had an
before you
issue with a
do,
neighbor.
if I can just
Neighbor-
add a couple points.
Sure,
to
go ahead.
what you mentioned. One, that miniature horse, that one's also allowed in the condo. You mentioned the HOA and how it can be extremely helpful in rural areas, but I've seen them in condos and it's the same answer. You still have to allow it if it's qualified as a trained service animal. The other thing I'll point out, we're here to talk about neighbor to neighbor disputes. What you didn't mention, Jeff, is what do we do about the neighbor that's complaining about this and saying, well, they shouldn't be allowed to do it? You've got two choices in reality. One, tell the neighbor, no, you're wrong. Maybe explain it. Probably don't go into too much detail for medical protection reasons. The other is ignore the neighbor. Do you have an opportunity or an obligation to actually respond to this person? Not necessarily. So I just wanted to point out, I'm sorry to interrupt, Lisa, but just a couple things that Jeff didn't really get to because there's a lot to break out in Marita's question.
And Alan, I'll add a
Yeah.
third item to your two. The third item is have them attend a Kaye Bender Rembaum webinar which we offer on assistance animals quite often, at least, probably, I would guess, at least 10 times a year. We have a webinar on assistance animals, everything you need to know. So please join us for any of those. kbrlegal.com is the calendar, and you'll see all the different courses that we offer.
Yeah, before Lisa, you jump to your question, that's what I was going to add there. For anyone who's on today, there are several other webinars if you go to the site, as Jeff stated, that maybe to a particular topic that we have not covered yet, you know, or that may be up and coming in the future, but you may be dealing with right now in your association. So you may want to jump in and watch one of those. So Lisa, back to you. Sorry.
That's okay. All right, Alan, you ready? We had an issue with a neighbor-neighbor dispute where the owner is discriminating against the neighbor based on their ethnic background. And it's escalated to them spitting on the neighbor and shouting obscenities in the clubhouse. The police have been called several times, and the owners want us as the association, the board, to address this. Like, where's the line of when we get involved and the board gets involved?
So 99% of the time, I'm going to tell you, if it's a neighbor-to-neighbor dispute, don't get involved. And if you are going to get counsel involved, it's to send a letter saying, hey, you need to understand you have the right to deal with this on your own. We're not going to get involved. But this situation is different. So you specifically mentioned that there's an allegation that the reason that one neighbor is going after the other or attacking, whether physically or otherwise, as soon as you involved any fair housing issues, that's, you know, your race, your age, your class, a disability, now all of a sudden the association under federal and Florida law has an obligation to step in and protect the disabled person, the person who is being, you know, attacked for their nation of origin, whatever that qualifier may be, the ism. Now all of a sudden the association does have the obligation to step in and say, hey, you owner that's pulling this stuff, you need to cut the crap now. Okay, this is a violation of federal law. It's a violation of state law. The association will not allow you to attack other members of the community. Now, some people will say, and others will say otherwise, that if it's a member getting violent with another member, the association has an obligation to step in. My perspective on that particular issue, because you mentioned that they're spitting at them, you know, screaming at them.
In the clubhouse.
Yeah, I mean, yes, I get it's in the clubhouse. It's on association property. But the association is not law enforcement. And that's who I think would be handling this type of situation, at least from a preliminary perspective of cut the violence. When it comes to the discrimination, that is an association issue. Whether it is or isn't doesn't matter. Whether it involves the association in any way other than it's on association property or it's happening within the community, or from my perspective, and Jeff may not agree with this one, if it's just one neighbor and another neighbor getting heated, even in a meeting that has nothing to do with the association, and the association gets a report of it. I think that probably is questionable whether the association has the obligation to get involved there. But as soon as you mention some kind of discrimination, that creates an obligation of the association to step in and protect against that discrimination.
Well,
Now,
what do you mean by protect against the discrimination? How far
to enforce the violation.
Yeah.
That's what I mean. To enforce the violation of any association covenants that basically say you're not allowed to attack this person. You're not allowed to, you know, step in and take these actions.
The
Jeff,
association has no firsthand knowledge. All they have is the allegation from one owner to another about the dispute, right? The two neighbors are living next to each other, and one neighbor absolutely, if the allegations are true, there's no doubt about it, there's discrimination against national origin, there's discrimination against race, whatever the allegation is that is in that little umbrella. But we're not a firsthand witness to it at the association, so we can't violate the neighbor, if you will. We have no way to do that except for the hearsay testimony of the next door neighbor who says, Joe said, my neighbor said. So what can we do there? And to the associations out there, I'm going to answer my own question. I caution you to be very careful, but I do caution you, you still have a duty to act. To Alan's point, I don't think you're in a position to fine and go that far because it didn't happen in the clubhouse. It didn't happen where we have association witness, if you will. But whenever you have an issue of discrimination, you have to protect the association. You have to do something. Even if we're just writing a letter to the alleged individual who acted in a discriminatory fashion, we're going to say, you know, we're not going to make the accusation that you did this. We're going to say, as the association, it has been alleged by a neighbor. It has been alleged by so-and-so, brought to the board's attention that, right, these things occurred. If they occurred, they should not occur. They must stop immediately. What you have to remember is if the lawyers, if this case gets litigious amongst those two individuals and the association did nothing, the association is in harm's way and it will find itself as a defendant somehow in that lawsuit. The association is the deep pocket. Let's not kid ourselves, especially in these big communities. So you need to protect the association. How do you do that? Well, you just show you did something, and something is better than nothing. But you've got to take these on a case-by-case basis.
Okay.
So, Alan, one of the really hot topics that we're hearing about from all of our boards and board members are the new gun laws and what they can or cannot legally do for any type of enforcement if they don't want someone, you know, coming into their clubhouse, you know, with a gun slinging down the side of their pocket, or owners that might be concerned that they see someone or know that they can now do that. And I realize it's different for condos and HOAs. So if you could kind of touch on that topic, that's been a real hot topic lately.
Do you mind if I hand your sandbag back first?
Yeah,
Sure.
if you look at your notes, Marita, it says that question is going to Mr. Rembaum, not to Mr. Schwartzseid, in defense of
Oh, you're
I'm
right.
happy to answer, but you know,
Sorry about that.
that wasn't the plan.
That was good. I was like, all right, Alan, let's see what you get there.
Hey, you know, I was seeing if the two of you were paying attention.
We appreciate that test. We do. Alan and I can play ping pong together, and I know my partner's got the answer to that as well. Interesting, right? If the government has involvement in your association, if there's a governmental nexus, we know the more governmental nexus that is created between the association and government, the greater the likelihood that the entirety of the Constitution can be applied inside the gates. But what if we don't have that governmental nexus, which is probably the case 99% of the time? Now, where are we? By the way, governmental nexus would be if governmental funds were used to help build out the association. That would be a simple example. We have the recent court case that basically said, yeah, concealed carry goes too far. Open carry is permissible, except in certain locations. Let's see where open carry is not permitted under the law. Let's see what we have. Any police, sheriff, or highway patrol station, any facility such as a prison or jail, a courthouse, any meeting of a governing body of a county, public school district, municipality, meeting of the legislature, school, colleges, professional athletic events, not related to firearms, professional athletic events, elementary, secondary school, career centers, places where there's going to be an airport terminal, check baggage, etc., and any place where the carrying of the firearm is prohibited by federal law. That's our backdrop. Problem we have is that the law is really open to interpretation because legislation has not caught up to this ruling yet. And the ruling is still basically wet when it, let's see, the court's decision became legal on September 25th, 2025, which gave the state 15 days to appeal the ruling, was what I had read recently. If you are a community association and you don't mind having a little bit of risk, then because why do I say that? If you're going to prohibit the weapons, we're talking open carry here, right? Because remember,
Mhm.
under the concealed
Correct.
carry, I used to get the question, can we prohibit concealed carry in the clubhouse? Well,
Mm.
there the answer is really simple because we didn't allow open carry at the time. So therefore, if you were not concealing your weapon, you were brandishing it. And that's a violation of the concealed weapon law. You're not allowed to brandish your weapon. Okay, that was an easier one. This one is not so easy. Florida courts have held that restrictions in our recorded covenants will not be invalidated absent a showing that they are wholly arbitrary in their application, in violation of public policy, or, here's the problem, or they abrogate some fundamental constitutional right. So, Second Amendment right to bear arms, is that a fundamental constitutional right? Probably. But we can also glean from the law that we can prohibit firearms in private locations. Can public say no firearms? It likely can. So now let's go to our clubhouse. We have remember, the common areas in the homeowner association are owned by the company itself, the association, right? It's a company. So the common areas are owned by the association, whereas in the condominium, here, all of the owners own an indivisible interest in the common elements. The clubhouse is a common element. All of us owners own an indivisible interest. Could there be a dichotomy between the HOA that prohibits the open carry versus the condo that permits that prohibits the open carry? And there could be two different ways that the court goes on those two issues. If you're going to prohibit open carry, I don't think I would prohibit weapons in their entirety. I would suggest perhaps maybe in the private context it should be concealed so that it's not open carry. But none of us can tell you how the courts are going to look at these cases. And there will be Second Amendment challenges on these.
Mhm.
So if you want to be out in the forefront, if you want to be in the vanguard, if you want to be the test subject case and you don't mind being the test subject case, well, then by all means, prohibit any type of firearm in your clubhouse, hands down. And if word gets out to the right people, you could find yourself at that association being that test case. You just have to know that going into this. They're going to want a test case. The gun rights advocates are going to want a test case. I like the position of sort of splitting it down the middle a little bit, just no open carry in the clubhouse, but concealed carry perhaps still permissible. The world is getting very dangerous. It sure is, and people are becoming more and more in your face. I wish I could be on this webinar right now and tell you associations, you get a clean bill of health, you can adopt a rule governing the weapons in the clubhouse, and also bear in mind, if the restriction is in the Declaration of Covenants, what does it take to put it there? A vote of the membership. Therefore, if that restriction is in the declaration, it has a much better presumption of validity and withstanding judicial challenge than it does if it's just a board adopted rule. Let's say you adopt the rule. Well, the very first question is, did the board have the power to adopt the
Right.
rule in the first place? Interesting question, but that's what you're going to, there are lots of things that go into the analysis on the board adopted rule as compared against the community voted on rule that's set out in the Declaration of Covenants. So if you want to withstand a better chance of judicial scrutiny, you put it in the deck. Know that there's no clear answer to the question whether you can do this or not right now. Marita, you want to say something? Alan, I know you.
Yeah, I was going to say, normally we tend to tell the owners they can't make a rule if it's not something that's covered in their declaration. So if there's no verbiage there and they just decide to create a rule on guns, I mean, we've guided them that that would be the easiest one for somebody to challenge.
What if the declaration said the board has the power to adopt rules governing the clubhouse?
Or
It does.
restricting
But
the
even though it doesn't have
So
guns,
so you feel that covers anything that they could, yeah.
no,
Okay,
I'm raising the question.
right.
Yeah, I mean, again, what if it's the declaration says that they board has the authority to adopt any rules governing the safety of the residents or the members, or, whatever you want to put.
Right.
Safety welfare. Right.
That
Right.
very easy
Right.
to cover the issue or not.
Right.
Those are the types of issues that in reality the association should be running by counsel, in my opinion, to get, at least if nothing else, the support that the directors individually can protect themselves from some liability by having relied on advice of counsel in whatever actions they do choose to take.
Yeah, it's kind of a catch-22 because sometimes, you'll have that owner, God forbid, something happened or there was an issue in a clubhouse and they say, well, you knew this
Yeah.
changed and you did nothing. You didn't put any rules in place. So, I'm concerned that sometimes they're open on both sides of it, no matter what choice they make.
It's
Well, and
definitely
the
a hot
other
topic.
issue that I have a concern about is the enforcement. I mean,
Right,
what's the enforcement? It better not be self-help.
right,
You're gonna
right,
walk in.
No.
right,
No.
Right.
What's the enforcement? You levy fines. It's a one-time violation. It's not an ongoing violation unless the owner, for the clubhouse example, moves into the clubhouse and never leaves.
right.
So what are we going to fine them $100? To a lot of people, if that is the cost of being allowed to carry
Fair.
whatever they want to go in the
Mhm.
clubhouse,
They're going to pay it.
it is a
Yep.
cost of doing business. That
Right.
has
But
no
every time
effect
they come in,
on those owners.
every time they come in, it would be that $100
Right.
100, right.
violation.
Agreed. But to some people, especially in some of the areas that Lang services and our firm service,
That's no big deal.
us to be able to walk in with an open carry pistol may not be a big deal. And then in reality, think about also how frequently an association that chooses to fine actually ever does anything about those fines. So if that's your remedy, it's really no remedy at all.
And Alan, I strictly remember when the hurricane shutters became an issue many years ago about people putting the shutters up and leaving to go out of town. We literally, Lisa, I know you'll remember this too. We had an owner walk into the office with a check for $1,000
Yes.
and said, I'm
out.
leaving for the summer. I'm closing my shutters. Here's your $1,000. I won't be at the hearing.
Right.
And they closed their shutters for the summer. So
Yeah.
I get what you're saying, that some people, it's going to be the point of it.
Right. For a lot of people, a fine is a cost of doing business. If you have enough money, that fine doesn't mean anything.
Right.
So what's your enforcement mechanism at that point? You file a
Right.
lawsuit to get an injunction to force the owner to stop open carrying into the community or into the clubhouse. I don't know that you want to spend that money, but as Jeff mentioned, if you want to be the test case, we'll be happy to earn that money.
Yeah, at least right now.
Does the board need to sit behind bulletproof glass? If every member in the association or many of them show up at the meeting and everybody's carrying, does the board need to have a howitzer on the board, on the dais to protect itself? Where does it begin? Where does it
Where
end?
does it end? Exactly. That's what's been happening to me. We've had to have Palm Beach Sheriff at a couple of our meetings. And one of the homeowners was very, adamant about the new law and encouraged everyone else to participate at the board meetings with
Well,
it.
Jeff's point, I mean, we're seeing a lot of people driving down the street on motorcycles carrying a rifle, high capacity rifle on their back. It's not limited to, okay, I'm walking in with my
Wow.
pistol.
Wow.
That's a good point too.
So,
Right.
this isn't just, hey, or am I allowed to walk in with my 17 round magazine? Or is it, hey, I can walk into the clubhouse with a 30 round magazine and a rifle, and that's okay now.
Right, and your AR-15, and you're saying, hey, I want to talk about my ARC application that you did.
Right.
Right.
Yeah.
Now we have on-site staff
On your
who is
back.
now, in a place where they're vulnerable.
Right.
Right.
But again, we have to remember that it is private property. So I think the association stands a fighting chance at restricting, most especially if it has the clear authority to create the rule. But you have to talk about it with the association's lawyer. Different lawyers are going to feel different. And most importantly, to the board members, they have to understand the potential risks in adopting such a rule as well.
Mhm. Well, a little bit of a piggyback to my comment about, the board member or the homeowner who was very vocal about his gun rights. we're having issues, it seems like everybody's just a little heightened, very excited about things at board meetings and you have a board that wants to look good to the homeowners, wants to hear them, wants to have an open policy, but they don't stick to the 3 minutes, for each homeowner to speak. And then you've got, people in the middle of the meeting shouting, back and forth.
You
It's
have to
become,
adopt true. And one of the reasons that they bring Alan and me and other attorneys in our firm to the meetings is usually after the board has completely lost control and they know they're having another meeting and they want the lawyer there to run the meeting because they think we are the panacea to solve this problem that they created. And Lisa, to your point, they created it
Yes.
by not either
Control.
adopting or not following rules
Correct.
governing owner
Right.
behavior at meetings. If you have that issue, even if you don't, you need to get in front of it. Every board should adopt rules governing member and board member behavior at meetings. For example, if the chair calls an item and no motion is made prior going on to the next item, each member gets their 3 minutes in the sun with the following rules created around it. No yelling, no cussing, no inciting a riot. You have to act like an officer and a gentleman. You can't give your time to somebody else. You're strictly limited. And somebody should be there with the 3-minute clock.
Yeah, we have a timer, but you get to the point where you have to be that,
Yeah.
company where you have to shut down the microphone.
Yes.
And it's not goodwill, when you get to that point, but it's
So much
definitely
easier to
starts.
do electronically on these Zoom meeting
It
platforms.
is waiting room.
Well,
We have physically had to take the microphone away from people because some of the associations, they'll put the microphone and a podium where you stand up and you come ask your question in front of the podium, where
That's
we've
right.
literally had to walk there. And I've had it with security where they've said, sir, you're done, and we're at the head table saying you're done. We really don't want to, have to have a security guard remove you. And yeah, it's not fun.
No, we had to tape the microphone to the stand, to the podium, because they would take it and stand in front of the board and just yell at them. So we taped it.
What happened to civility? Where has
It's a big challenge for us in these meetings now. It really, really is.
I'm surprised to hear you say that because in my world, it seems like it's gotten a lot better than maybe I'm going to go back about
No.
8 years ago,
No.
9 years ago, where
You
it
know,
could be a whole lot worse.
I feel like, Jeff, after people came out of COVID, whether they were just not happy because everybody was in their house for so long, whether they did or didn't like their spouse, it was a long time for them to be with their family and only their family. I feel like people came out just anxious and not so nice, and social media
That's
has
tolerance.
really fueled, I don't know if you remember that song many years ago, So Much Cooler Online, where you post anything you can say about anybody. And, they don't see who you are. Even though it's just a name, you're not out there in front of someone seeing what you're actually doing to them. That social media is a problem. It's not just in high school. Like I've even said to my managers, some of the, in our 55 and older communities, they're just mean people who were mean in high school and now they're mean in their older years to each other. And it's sad to see that happening to some of our.
They have message boards that are very dangerous, and it's social media.
Well, I think it's social media, but also the media in general that is
Correct.
advocating
Fueled everywhere.
vision.
Agreed.
And social media expands on it. You've got keyboard warriors, like Marita said, that just think that they can say whatever they want with no repercussions. And unfortunately, along the lines of what Jeff mentioned earlier, people are scared of other people because you know who's going to do what. I mean, God is great, beer is good, and people are crazy. And you never know where anything's going to go when you decide to get into one of these disputes with someone. So it's that balancing act between, do I just come out and say whatever the heck I want? That's not really my mentality. Or do I try and make sure that anything I say, I'm able to back up and it shouldn't get me killed? And I think that that's extremely difficult to maneuver, especially within a community association where inherently people are being told what to do and what not to do. I mean, it's an HOA and a condo in reality are the living accommodation version of a high school. And you guys mentioned high school mentality. Unfortunately, a lot of people in community associations have reverted to that mentality.
Right.
And I think
Well,
some of it is social media, some of it is the media, some of it is just, like you said,
who they always were.
it's, and yes,
Right.
it's the internet gives people the ability to expand on their good traits and also their awful traits. And I think we're seeing more and more of that as the internet becomes the day-to-day, and the cell phone and the watch and the glasses, all of which give you new information if you ask them to. I think it's like getting ready for the world that existed in Wall-E, that Disney movie, where everyone is just attached to their tablet all day, every day, and no one really thinks about whether or not what they're saying is appropriate or correct.
Right.
I hate to say
And
it, but I wish there were more consequences for bad actors, because I think if I'll use the initials, but if the FAFO started to really happen and the FO, the find out part, started to actually be an issue, I think people would be a little bit more hesitant to be rude to others. But
right.
the
You know,
society is so litigious that the second
mhm.
you go on the counterattack or you respond to someone, it's, oh, I'm being attacked.
Yeah.
Right, you're
You have
correct.
board
So,
members who run for the board and they're not paid. They're homeowners just like everyone else, and they're treated badly.
And that's
terribly,
where this is
terribly.
becoming
So,
problematic. We're putting such a burden, an administrative burden created by this legislation that we're seeing every year. Oh my gosh, right? To be a board member, and you now an HOA board member, 4 hours of continuing service
or
of
8,
patient
Or
rather.
8 is a condo.
depending on the
Or
size of
eight
your
if it's
community, it could be
larger.
up to
Yeah, the
8.
size.
Right. It's only 1 hour, 1 hour continuing education for the condo. It's so strange, right? You've got a
Mhm.
4 hour continuing education requirement for HOA, 1 hour continuing education for condo, but to be board certified in the condo, you have to do a 4 hour class, and the HOA class has no amount of time that regulates it, if you will. There's
Mhm.
such a disparity between the two. HOA
Mhm.
sometimes not enough, condo they've over-regulated. There needs to be a balance.
Mhm.
Well, as we're speaking about people's behavior, one of the other things, Jeff, another common issue, unfortunately, we now have in several of our communities mailbox clusters. There's not individual mailboxes where they put the mail in as they did in years past, and it's very confrontational, these homeowners at the mailbox clusters. The people who want to pull right up front and run out and grab their mail and come back to their car, and they're not supposed to park there. And there's other people who are parking and walking, whether it's raining or not. But I mean, we literally had an instance in one of our communities, about a week and a half ago, where the postal worker had blocked off the area because you're not supposed to go get your mail when the postal worker blocks off that area and they're putting mail in the bins. And a homeowner, it was a female postal worker, a male homeowner who went off. I mean, I'm talking dropping all kinds of inappropriate words in her face. They ended up calling the police because it's a federal offense to
Mhm.
treat a postal worker like that. But this was literally over a mail package that someone was picking up on their mail. And a lot of the boards are frustrated with people who, I mean, it is rude if you're the one that thinks that you should just pull up front when everybody else parks in a parking space. And, you think that you can treat that postal worker any way you want. So what advice do you have for associations on those mailbox cluster areas, and any rules or anything that they could implement?
Brings back the open carry conversation we just
Yeah, exactly.
um brings up the civility we just talked about. It is difficult. Clearly, if the association has cameras, that should be one of the monitored areas. There should be rules crafted. If you want to prevent the vehicles from pulling up directly in front of the mailboxes, there should absolutely be a rule prohibiting that, so that the association then has enforcement powers, everything from fining, use right suspension, seeking an injunction against the individual from doing so in the future. It doesn't take much for word to get around. Once the association finally takes the position, we ain't taking it anymore, and word gets around. So sometimes we have to be our own best advocate on the board. We have the power, board members, you have the power of the pen. There's no reason you should not be communicating with your membership. And in fact, I suggest that you should be communicating monthly to your membership, and quarterly at a minimum. Let them know what you're doing. Let them know what's going on. Let them know that, yes, we have started an enforcement action against an owner who continually brought their trash out on a Tuesday when garbage pickup isn't until the next Monday. We started an enforcement action against an individual who refuses to park their car and pulls up in front of the mailbox gates. Please don't be the next one. Don't make us spend our association revenues this way, right? You just need to get around the situation, work with the lawyer, craft reasonable rules and regulations, and then you have to amp up on the enforcement arm.
I mean, I agree.
Thank you.
The only thing I'll add is when you've got those situations where it really does become either threats of violence, actual violence, frankly, rather than spend money on having your attorney get involved, again, I would call the local law enforcement and have them deal with those criminal violations and criminal penalties. Similarly, if you've got things that are, not being maintained the way that the local code requires, someone put up a shed without a permit, get local code enforcement involved instead of spending association attorneys' fees. Use whatever resources you've got available, to Jeff's point, to make sure that there is something going on when you see these violations coming up. Because if you're just ignoring them, then all you're doing is waiting for a couple hours of attorney's fees to send a republication letter of your governing documents and your covenants and your rules and regulations that really shouldn't be necessary, because in reality, you should just be enforcing your covenants from start to finish, day in, day out, except when there is a true exception to the rule for a specific reason. It's problematic when you're not getting the money that you're entitled to because you won't collect assessments unless someone owes $2,000. Or if you're not enforcing violations because you think, well, this one's no big deal. But it gets to a point eventually where everyone looks at every violation as though it's no big deal, unless you're actively enforcing pretty much all of them.
We seem to be having a lot of rule in place, putting them in place, because when we have all these little things that go on, like one issue we've got that keeps coming up in seasons coming is when they go to put the towels on the chairs and save them, and they're going to have breakfast, they're coming back, and then now we've got an argument full force going on between two homeowners, at the pool. What advice can you give us to help us address or kind of help us control or preventing that to kind of happen? I feel like, we'll put a rule in place and tell them they can't save chairs, but it doesn't stop them from doing it.
Well, I mean, I think, like I just mentioned, continuing to enforce the violation the way that you customarily would. It's the 1 or 2 letters from management, potentially fining, although I don't really like fining, potentially suspending their right to use the pool altogether if they refuse to stop violating these things, and potentially eventually getting to the point where you seek an injunction through your attorney. But if you're just not enforcing and you're basically saying, hey, we've got these 100,000 rules that we put into effect, but we're not going to do anything with them, what's the point in adopting them in the first place?
Yeah, it's difficult though. Like, I know, get a receptionist, you've got the admin, or you've got a social director who goes out. We may not know who the homeowner is, and they're not willing to tell you either. So sometimes we have to go back and look on cameras. It becomes an ordeal over a chair and a towel.
A rule, adopted by the association, and any items left on a chaise lounge, any unattended items left on a chaise lounge greater than 1 hour will be collected and deposited at blank location, and you'll have to go there to reclaim your item.
Lost and found. Good idea.
Well, lost
And
and
then
found,
also-
maybe to the front desk, who knows?
It was
And by
found.
reclaiming it, you're also acknowledging that you were the one that violated.
Yeah,
Correct. That's a good idea. That's great.
Right.
We've got some questions in the chat.
we do.
We do.
And I think, Lise, just before we go to those, I think, Jeff, we wanted to cover pre-suit mediation, when you think it's necessary,
yeah.
and what
Pre-suit
other
mediation.
remedies are available.
For most items, not every item, but for most disputes, especially neighbor to neighbor, the kind of things, rule violations and such, Before you can go to court as an HOA, you have to go to pre-suit mediation. As a condominium association, you would have a choice. You could go to pre-suit mediation, and if it doesn't work out, then you can take it to court, or you can go to arbitration through the Division of Condominium in Tallahassee. There's pros and cons with both. Take it on a case-by-case basis. Here's how the pre-suit mediation works. It's interesting because when you read the Condo Act, for that particular part of it, it says, refer to 720, refer to the Homeowner Association Act for the pre-suit mediation requirements. But here's how it works. The aggrieved party, be it the association or the homeowner against the association, has to send basically a pre-suit statutory demand letter. The letter is governed by statute. It has certain requirements, certain language. It needs to be substantially the same as what's in the legislation. But the short story is you'll have all that. You'll have the nature of the violation. You have to provide the name of 5 mediators. The other person, the recipient, be it the association or the owner, then has to choose within 20 days one of those 5 mediators. Now, when the aggrieved party sends the pre-suit mediation demand, first class U.S. mail, certified return receipt. When the recipient receives it, they sign that they're going to participate, and then they circle the mediator. When they send it back, it's not just email, it is U.S. mail and certified as well, certified return receipt. If the responding party messes that up, oh, what a mess, because now the other party, the association, let's say they're the aggrieved one, they're the upset one, the association can now say you didn't comply with the pre-suit mediation, we can go right to circuit court. So the requirements are very, very strict in how it works. It is wonderful. So we have a dispute. Association sent the pre-suit demand, sent it certified U.S. mail, first class as well. The aggrieved owner received it. They were a good aggrieved owner, quote unquote. They sent it back to the association correctly. They circled a mediator. We're good to go. We have 90 days to set that mediation. Now the mediation is going to be set. How does the mediator get paid? Each of the parties pay 1/2 of the mediator's fee for their time and whatever other requirements that particular mediator may have. You'll find that about, I don't know, but your experience, Alan, but I'd say 85 to 90% or so of the disputes do seem to get resolved at pre-suit mediation. I think it is a fantastic tool. I like it so much so that I would rather see an condo association use pre-suit mediation, and if things don't work out, you get to go to circuit civil, as compared against arbitration, because when you're dealing with mandatory non-binding arbitration, it's kind of an oxymoronic term, mandatory but not binding. I got to do it, but it doesn't matter. Really what it means is mandatory, you have to do it. Non-binding meaning once the arbitrator rules, either party has 30 days to then appeal that ruling into the local circuit court. That's the route those cases take. Problem is when you're dealing with the division, they don't even have to follow their own precedent. Oh, we had an election case. An upset member is aggrieved about an election. And in this particular case, they filed a complaint to the Division of Condominium, who has jurisdiction over HOA and condo disputes. Make a long story short, the association had only received a couple of days' notice. It was basically the owner said, either have a new election and let me know, or I'm going to file this complaint. And there needs to be a sufficient amount of time for the association to get its act together to decide what it wants to do or not. A couple of days is not sufficient time. 5 days is not sufficient time. And there have been multiple cases from the division saying just that. And now, in a very recent situation, the division comes back and the arbitrator says, I'm the one that first came up with the fact that 5 days wasn't enough time, and I now overrule myself. And the 5 days that the aggrieved owner gave the association was plenty. And we're scratching our head thinking, oh my God, they just make it up as they go. There's no stare decisis. There's no precedent. There's no having to follow court case outcomes. They can decide a case however they want to, and there's no repercussion. So what would you rather have? A judge who's actually learned and trained in the law to be your decision maker, Or would you rather have someone who's a state employee? No disrespect. I mean, I respect them for what they're doing, but do they have the knowledge that Alan has? Do they have the knowledge that I have? Guaranteed, not even close. Right? Are they board certified in the field? Should there be a requirement that any arbitrator is board certified? You bet there should be. So lots of different things go into these decisions, right? And bring me back to your original question. I've spoken so long, Marita. Oh, presuit
You're good.
I think we pretty much covered that. It's in the
Mhm.
statute for most disputes. If you're going to want to challenge your association, especially in the HOA, you're going to have to use that statute. Again, not everything, and there is a mechanism if you need an emergency injunction. There is a mechanism to do that as well. So you can move things forward when necessary. Alan, I'm sure you want to jump in. Alan and I, just so everybody knows, are both Florida Supreme Court certified mediators for Circuit Civil Court. We can handle your disputes if you need mediators. As long as it's not clients of the firms, we're happy to help out and play the role of mediator, which actually I think Alan, you and I both really enjoy.
Correct. I mean, so I will say part of the reason that I became a mediator was a long-term retirement plan. But the bigger reason that I chose to do it was because I was seeing how successful these mediations can be when you've got a mediator that knows the area of law they're mediating, that can get creative and find solutions. And that's what we bring to our clients as well. But as a mediator, I try and do the same thing. I don't see that happening when you go to arbitration. It's here's my unilateral opinion on how this case should play out as the arbitrator. And as you mentioned, Jeff, it's in, there's even case law that says the arbitrators get to be arbitrary in the way that they rule. So the expectation that you're going to get someone that, one, as you mentioned, Jeff, knows the law, or more importantly, as you also mentioned, too, will follow the law. There's no reasonable expectation that either one of those is going to happen when you go to arbitration. And again, I'm not trying to dissuade anyone from relying on the state to provide qualified individuals, but I do agree there should be maybe a mini exam that these people take before they get to decide issues that pertain to community associations. Because if they don't know what they're doing or what they're talking about when it comes to this area of law, not that they don't know how to be an arbitrator, but they don't know the area of law well enough, and they don't listen when the attorneys tell them, here's a very clear case that's directly on point to our situation, and they just arbitrarily ignore that case law and then intentionally reduce the attorney's fees that the attorneys are spending by 30%.
Oh, they have no problem awarding the homeowner attorney's fees when the association is paying, but yet when the homeowner loses and the association wants to recoup its monies, it seems like there is a significant haircut there, more
Well,
so than the other way around.
the way that they handled it, and I was one of several that recently discussed this with some of the division officials, they're taking Tallahassee rates from about 20 years ago, and that's the rates that they're applying across the state. So mediation, as compared to this arbitration, you get in a room, you try and settle. If you're not able to, you go to court and you have a judge who can be appealed to a higher court that's even more learned than the judge. Versus you get in front of someone who can decide whatever the heck they want based on whatever factors they choose to consider and completely disregarding precedent.
And the same arbitrator could have the exact same fact pattern in two different cases and rule in two completely different directions because they wanted to.
Including, by the way, I've seen that with the same parties,
Oof.
the same issue,
Oh,
and the same arbitrator ruled differently.
you just can't make this stuff up.
Right. So
Very-
my perspective is mediation is just more efficient. You're going to go, you're going to meet up one time, then it's done and you go to court if you don't settle. The other thing about mediation is, when we get back into some covenant enforcement issues, if you're going to threaten self-help, you can have that scheduled for the day after the mediation conference and kind of keep that hanging over the person's head when you walk into mediation. With arbitration, this could take 4 or 5 months before you actually get a ruling and then have to take it to an actual court to decide if you choose to appeal a bad ruling. So again, I think that the mediation, it's a process of trying to resolve a conflict. It's kind of like when I say, listen, it might be better to work something out with the owner, get them into a written agreement that has severe consequences for a default, rather than spend another year and a half litigating the issue and spending more money. Mediation gives you the chance to do that. Arbitration is another combative procedure where you're up against the other side. Whereas mediation, as Jeff mentioned, I see a lot of these cases, maybe not 80, 90%, but probably closer to 70 to 80.
Okay, I'll take it.
Still pretty damn good. You know, I'm seeing a lot of those cases. The people that care enough to go to mediation are generally the ones that are not just going through the motions. They're really trying to get this resolved, and they just don't want to be battling with their association.
And it's
So my perspective is go towards the conciliatory, let's get it done, even if you're taking an aggressive stance during that conciliatory meeting versus just hoping that the arbitrator knows what the heck they're doing.
and the bad news. What's it going to cost me? Right? Hear that all the time. In a pre-suit mediation, before it's all said and done, I think the association can expect anywhere between 2 and 4,000. I could say 1,500 and 3,500. Really just depends, but you have a little bit of workup. You have a little letter to the mediator explaining what the situation is, what your position is. That's a confidential letter. You have to pay half the mediator's fees, and you have to pay for your attorney on the day of the mediation itself. So you do have some expenses, but I think it's money well spent. It's not, necessarily recoupable. It can become one of the negotiating points at the mediation to try to settle it. Well, if you settle it, Mr. Owner, we'll pick up all the costs, all the fees, whatever. Sometimes either party may say that to the other, but it is generally speaking money well spent. Running an association is running a business. Not everything you do in the business is compensable, but when you sell your goods and your wares, if you will, that's how you are supposed to be raising enough money to cover the operational needs. What do we sell as the association? Well, it's not really selling, but we have our assessment regime, and you have to build that into the assessment regime. So build a few $1,000s in extra into the assessment regime, knowing that the world is going in this direction of pre-suit mediation. And if, to your points earlier, Marita and Lisa, if you want the owners to take you seriously, if you don't want that individual parking in front of the mailboxes anymore, let's get them to pre-suit mediation. Let's let the community know we're not taking it anymore. And until the community does that, this fellow's going to keep parking in front of the mailboxes.
Thank you. And I know, Lisa, were several people who had questions in the chat box. We do have those questions that, we will get back to you.
Well, do you want to
There were
ask a
also
couple of
some that,
I'll stick around for another minute or two if our listeners want to. We can kind of judge it by the participants that are staying somewhat constant. So if you want to ask one or two questions, see if we can knock them out. Go for it real
Lisa,
quick.
you want to pull a couple of those off?
Yeah, one of them I thought was important. It was they wanted a clarification.
They were asking Alan, whatever it is.
Please
I'm
clarify.
sure.
If
I'm
my gun
sure.
is concealed and I go to a board meeting,
Yeah.
no one will know, correct? Question mark.
That's correct. Right.
This
That's the way
individual-
the concealed weapon, the
Right.
concealed carry laws
Right.
were supposed to work.
Right. This individual could have been carrying at every meeting and no one knew. The issue
Right.
here is open carry and people can continue to carry their gun concealed, question mark.
Well, you could, yes. I mean, yes.
It doesn't take the place of the concealed. You could do
I
either.
don't think so. I think you still need to have your
Yeah.
permit for the concealed weapon.
Yeah.
I'm not an expert in these laws. I suppose I could take a day, study up on them. But you can have a concealed weapon, but it's a concealed weapon permit. So I would suspect you need the permit to have the concealed weapon, whereas everybody has the right to open carry. Go figure that.
Mm-hmm.
I reserve the right to be incorrect on that answer.
When a member who complained that her neighbor was encroaching on her property, such as planting some shrubs on her property, she demanded that the POA get involved and make the neighbor remove the shrubs, etc. Since it is a private property between homeowners, does the POA really have any reason to get involved?
Not from my perspective. I mean, that is the quintessential situation, other than the lack of an architectural application potentially.
That's what
I don't even know what enforcement the association would have available to it. My perspective is the first step would potentially be, again, you send a letter to both, basically saying, listen, I understand there's a dispute amongst you, between you, whatever, but in reality, it's not one that the association has any reason to get involved with, and specifically to spend the funds of all of the members to address an issue which, as of right now, only really exists between two lot owners.
Actually, I have slightly different thought on that one, Alan, depending upon if we're dealing with single family home in a 4 home per acre community. I tend to go in the direction you just kind of went there. Unless the person is not, it's one thing if the vegetation's on the property line. It's another thing, I think, if the vegetation we're talking about, one owner builds 10 feet into the other neighbor's lot. I think that's an issue that has to be looked at. But then we have the 0 lot line communities. And
Mhm.
there, I think the association may need to step in a little bit more so than in the 4 home to an acre type situation, because we have to perfect, the association really needs to perfect those easements that exist to create those 0 lot line communities in the first place. So it's dicey. There's no one answer fits all, you know?
Can you challenge if an animal is service or ESA? What type of documentation can we request?
Yeah, hide. As soon as you ask that question, I want you to hide behind the lawyer. Members have individual liability for missteps under the fair housing laws. Now, I haven't seen that play out where someone who got tagged, but I don't want any of our listeners to be the first ones either. If you're going to accept the assistance animal, you don't need the lawyer. If you're going to probe the assistance animal in any way, hide behind the lawyer. That's my best advice when it comes to that particular situation. And your question was, again, Lisa? The actual question
The
was,
ethical question is what kind of documentation would they request so that, service versus ESA?
does the individual have a disability? Does it affect a major life function? How does the animal help ameliorate the disability? So, does the person have a disability? Is it readily apparent? If someone's in a wheelchair, you can't probe the disability. If you do, you did a misstep and it's actionable right there. Then you have the right to know how the prescribed relief, what is the prescribed relief? How does it relate to the disability? How does it ameliorate the effect of the disability? So many different ways, but you've got to be very artful in how these questions are probed, how these questions are asked. And we do it very delicately, very gently, if you will, when we are involved in these matters. And we know which issues are already cleared and which issues to probe. Whereas the ordinary person sitting at the board level really is not well equipped to deal with these issues. And it's not fair to put it on the manager. Alan, you want to jump in anywhere on that? Feel
No,
free.
I think you hit it on the head. I mean, the only thing that I will mention is just to be careful. Like you said, you want to make sure that you respond within a reasonable time. What qualifies as a reasonable time? There's really no specific metric. It's kind of on a case by case basis. I've seen case law that says waiting 2 weeks to get a response out is too long and it qualifies as the equivalent of a denial. So I would just make sure, to Jeff's point, if you're going to rely on and hide behind your attorney, make sure to get the attorney the information and ask them the question in a reasonable, time frame. And if you're aware that your attorney has a backlog. I've heard of some attorneys, I can't speak for South Florida, but up here in Orlando, where you can't get any response for a month. It might be time to find another attorney when this type of issue comes up, because that's too long. And chances are it's going to be treated as a denial, even though you never reported back any kind of rejection of the accommodation request to the person requesting it.
I want to clarify for our listeners when Alan mentioned that time frame. If you give the requesting the assumed disabled individual only 2 weeks to provide to you the requested information, that's probably going to be a violation under the federal law. You need to go and provide a decent amount of time for the individual to get back to you. And I think, Alan, your time frame was different. Wasn't talking about the
It was.
long.
I was talking about the time frame for giving the yes, you can have the accommodation, or no, you can't. If you wait too long to give that response
Mhm.
without in the interim saying, hey, we expect to have a response to you in the near future, or hopefully on or before this date. If you don't respond within a reasonable time is the only thing that the
That
case
too
law.
is a violation. Yeah,
That's
absolutely.
also a violation because it's treated as having rejected the request.
So many missteps when it comes to
Yeah.
fair housing out there. So many, which is why I typically say hide behind the lawyer.
Be careful, right?
Yeah, yeah.
That's what we usually do is we refer it to the attorney and have them handle it directly, especially when it's between the two parties. But
Marita, we have about 3 more minutes or so. We still have most everybody with us. You want to throw one more quick fire? Or at least
so let's see, we'll take one from some that we got in ahead of time. What can you do when a neighbor refuses to stop smoking on a catwalk? There you go.
You hear that a lot.
Yeah, we do. I mean,
We saved the best for last.
the reality is that's another one of those, in my opinion, that really needs to be supported by the declaration in some way. The question is, what kind of support does it require? Is it a health and safety issue? Is it, the everyone else is it a nuisance where the smell is getting to everyone, or is it that the neighbor, which I've dealt with in Miami, is cannot breathe in their unit because the person in the unit above is smoking so much and the smoke comes down into their unit. That's one of those I would run it by the attorney based on the circumstances of why it's problematic in your community.
I take a position that the board is probably within its rights to pass a rule, no smoking in the common areas. But if you're going to prohibit smoking in the units, to Alan's point, you darn well better be taking a membership vote amending the declaration. It has been held that smoke is a particulate matter. It is something, it is physical. Therefore, you can use the nuisance provisions under the declaration to enforce the no smoking provisions. Sometimes it could be a hypersensitivity that an owner has. And in that context, it may not be as actionable because somebody has a hypersensitivity to the smell of garlic and this owner is cooking with garlic. And do we have a lawsuit there, right? But the courts have held that when people have unique individual hypersensitivities, well, that might be on the person that has the hypersensitivity. But if you want to pass no smoking, I've made buildings no smoking through votes of the
Right.
owners. I've made common areas or helped the boards make common areas no smoking as well. Always gets a caveat that and I'm sure Alan does too, if this is challenged, we cannot promise our court's going to look at it. We've done our very best to withstand judicial scrutiny, but however, there's always that chance this could be overruled, overturned.
Yeah, and the
And
other,
we have had condos that are now a non-smoking building for the exact reason that Alan said. The smoke comes through the air vents. It
Mhm.
does. It's,
Yep.
and unfortunately, if you're next to or around a unit and they smoke, it does affect your unit. So yeah, it'll
Are you
be
sure
interesting to see if that's,
Are you sure the condominiums aren't proof that God did not intend people to live so close together?
Yes.
yeah, yeah.
just expanding real
Well,
quickly on Jeff's point, what about the individual, and this maybe we'll leave you with this. What about the individual who claims they have a disability that causes them not to be able to breathe so well, either just because of age or whatever, and they do have a particular problem with smoke, but it's because of a disability? Now, how do we give them an accommodation by forcing other people not to smoke?
Mhm.
Good question.
right.
Not one I have an answer to, but it's a question.
It's a good pickle.
Right.
So I really want to thank you both, Jeff and Alan, for doing the Association Matters with us. We're trying to bring to you issues, and even our associations, whether you are an association, with Lang or not, we're trying to bring you issues of concern that we can discuss with the attorneys openly, to come up with some solutions that help you. We appreciate you all attending today. And our next one is going to be December 3rd. We are going to move them from 12 to 1 so that if there are people that are taking their lunch break, they could. Alan, we moved it.
You mean
Right?
from 2 p.m. to 12 p.m.?
To 12 p.m. Yep, we're going to move it to 12 p.m. on December 3rd from 12 to 1. So that if there are people that are, some people are still working, they're interested, they want to attend the Association Matters, we're going to do it at lunchtime. So more
And let
people
us
will
know
be
what
able
you
to
want us
attend.
Talk about too. That would be helpful.
Yeah.
Yeah.
Give us, if you have some ideas that you'd like to hear, let us know. Again, Lisa and I take it from what we hear back from our board members to try to keep everybody informed. And we really appreciate, Jeff, you and Alan taking the time to help us and
The
the
opportunity.
homeowners that we
Always our
serve.
place.
Thank you.
It's our way of
Thank you.
giving something back.
Thank you.
Have a good afternoon, everyone.